If I rush at any point, I apologise. I am going to attempt to try and cram an awful lot into this because I know it's a topic that everyone wants to know a lot about. So if you don't catch anything, please catch me afterwards. I'll be happy to talk about any questions in the break. My colleague Romin is here as well. He'll also be happy to talk to you if I'm all wrapped up and busy. Okay, so I'm going to jump straight in. My name's John Langley. I work at the Information Commissioner's Office. I'm going to assume that everybody is at least vaguely familiar with who the ICO are, and I don't need to go into that. I've worked there for about 10 years now, doing a number of different roles. I've dealt with complaints. I've worked in our enforcement department. No, we're okay. And now I work in our technology policy department as a senior technology officer. So my job there basically is to understand technology and how it impacts on effectively data protection legislation, and to write guidance on that topic and provide advice to the rest of the organisation. So when somebody in the rest of the organisation comes to us and says, what's a cookie? We can tell them what it is and what the implications are. What I would describe myself as a technology generalist rather than a specialist. That means I know a little about a lot rather than a lot about a little. Okay, so if you do have questions for me and it's a very, very deeply technical question in a very specialist area, please be understanding if I don't know exactly what you're talking about at the time. Okay. So, what I've decided it would be good to talk to you about today is the General Data Protection Regulation, or the GDPR, and how it applies to the internet. And what I'm basically going to try and say to you is that it's not a revolution, it's an evolution. It's an evolution from the original legislation that we've had, which was the Data Protection Act. So, hopefully this won't scare anybody. I presume you're all well on the way to being ready for your implementation next month, because we are getting really quite close to the implementation date now. What I would say though is, if you are panicking, don't. What I'm going to try and set out here is that actually there aren't any huge changes. If your compliance under the Data Protection Act was good, you're in a good place for GDPR already. There are just a few things that you will hopefully already have been thinking about, but we'll move on to look at those. So, let's have a quick look at some of the key principles and the differences between the Data Protection Act and the GDPR then. So these are the principles from the Data Protection Act. I'm hoping that these are all at least vaguely familiar to many of the people here. I won't go through them one by one because this is the old legislation, and as I said, I'm going to try and get an awful lot of information to this that I can. So there's 8 principles there, basically, and if we switch over, we'll see what's there in the GDPR. And what you'll see, actually, is that there are 6 main principles and then an additional one, so 7 principles. And broadly speaking, most of them actually map across. There's a couple of little differences, which I'll just quickly highlight. Subject rights are now no longer included as a specific principle, and neither are international transfers. Both of those are just in the body of the regulation itself, but that actually mirrors the original directive that the Data Protection Act was based on anyway, so it's not actually a huge change. The way they work is, broadly speaking, quite similar. One thing that is worth highlighting, though, and this is something that is a change, is this bottom one, the accountability principle. Okay? What this now means is that not just complying with the principles, you now also have to be able to demonstrate that you are complying with those principles as well. So what that means is, if we as the ICO come to you and say, how are you ensuring that your systems are secure? You'll actually have to have documentary evidence that shows how you are keeping your systems secure. You will have to have policies and procedures in place. Now, realistically speaking, this is actually not that much of a difference from what was, not necessarily in place under the Data Protection Act, but what we would actually expect. When I was working in enforcement, one of the first questions that we'd ask if we were dealing with an incident was, what policies or procedures did you have in place to prevent this kind of thing from happening? So realistically speaking, you were kind of expected to have a lot of this stuff in place anyway. The accountability principle now just actually makes that a requirement within the legislation in and of itself. Okay. Where are we? Next slide. The other thing that's slightly changed is the definition of personal data. You can obviously see the text from both of the two pieces of legislation there. Now, these look a little bit different when you first look at them. But that's mainly due to the way that the UK government interpreted the DPA into our national legislation at the time. The definition in the GDPR is actually pretty similar to the one that was in the European directive that we got the Data Protection Act from in the first place. What we're looking at here, though, is actually just refinement rather than significant change. So what you'll see in the GDPR definition, there's a few new specifics that are now actually mentioned. So you've got location data, online identifier, genetic data, and so on. But actually, these are all things that were covered under the original definition of personal data. They're now just spelled out more specifically in the text. Obviously, I suspect the one that you've all kind of homed in on there is online identifier. That doesn't mean an online identifier will always be personal data. It just means that there will be some circumstances where it is, and this is a good example of that. So if you want to look into that in more detail, IP addresses are a fantastic example of that. If anybody's familiar with the Breyer judgment, which looked into this principle, basically what it said was IP addresses are sometimes personal data. It will depend on the circumstances that you're looking at. So a static IP address, for example, assigned to a specific individual is going to be personal data because it links directly to that individual. Okay, that's a very, very simple level. But it's important to note that actually online identifiers are specifically called out now. Okay? Hopefully that will be of assistance to you. Should you be needing to explain whether or not something is personal data within your systems. The other thing we can look at is how data subject rights have changed, and we'll see again that there's not a huge difference here. Broadly speaking, the rights that you had under the DPA, the right of access, maps across directly. Right to rectification, blocking or erasure are the ones where there's a slight difference, but actually, broadly speaking, most of those map across. If anybody's seen that right to erasure up there, I am going to talk about that in more detail later on. Don't worry, I'm not just going to skip past it here if that's something you are quite interested in. The new rights, basically here, obviously you can see the right to object maps straight over, and automated individual decisions also map straight over as well. The new ones here, there's a notification obligation concerning the rights listed above it, Articles 16, 17 and 18. And what that means is if somebody exercises those rights, the data controller is under an obligation to notify other people they have passed that data on to about the exercise of the rights above. There is a slight difference in how these rights are enforced. Under the Data Protection Act, all of the Section 14 rights were only enforceable by taking it to court. You had to apply to a court in order to exercise those rights. Those rights now fall back to the regulator, so they now come to the ICO for initial thing, although you still have the right to take it to court should you choose. Restriction is also a slightly new right, but actually it, broadly speaking, brings together rights that were already contained within the DPA. It just actually, again, makes them more specific. Data portability is something that you might have come across. I suspect it's something that some people may have worried about in the room. This is not quite the powerful right that a lot of people have kind of envisioned it to be. Quite a lot of people have described it as SARS on steroids, SARS being subject to access requests or requests for your personal data. It's a limited right, and it is aimed at fostering competition and enabling individuals to have personal data that they've provided to a controller, provided to them in a commonly used machine-readable format, or to have that data ported to another provider. Okay? The important thing to note here is it is a limited right. It only applies if your condition for processing is based on consent or on the performance of a contract. So it is a very limited right. It is still something you need to think about if the processing that you're doing does fit under that, but it is limited, and it's not quite the catch-all that everybody thinks it is. And the other thing, final comparison, before I'll move on to the slightly more specific stuff, is the lawful basis for processing. So basically these are the conditions for processing that you have to be able to apply to the processing that you're doing for that processing to be lawful. So on the left here we've got the basic ones under the DPA. The important thing to note here is that there are 6 of them, and none of them were any more important than the other. This is a really, really common misconception. A lot of people thought and still think that consent is the one that is important and that you have to be able to look at. That is not true. Consent is only one of the conditions that you can meet. If you can meet any of those other conditions for processing, consent is irrelevant. And if there's one thing that you take away from today, please let that be it. It's a really, really important point. One of the key misunderstandings there, I think, has been that there has actually been no definition of consent in the DPA. It was never actually defined in the DPA. You have to go back to the directive to get a definition for that. What we now have under GDPR is exactly the same. All the processing conditions are exactly the same. The only thing that's changed is that we now have a specific definition of consent directly applicable in UK law. And this is what has caused quite a lot of fuss. A lot of people are very concerned about it. So basically, if you're looking at your conditions for processing or your lawful basis for processing under GDPR, if they were fine under the DPA, they'll be fine now. Unless we're going to look at consent in a second. Okay? So what is the position on consent? Okay. Article 7 in the GDPR gives a full layout of all what's actually required for consent. We've also now published guidance on this topic, so you will be able to find that on our website. It literally spells out all the stuff that is there for consent and goes into quite a lot of detail, talks about consent for marketing, talks about business to business. There's quite a lot of good stuff on there. I would suggest you have a good look at that if you really need to get yourself up to speed on consent. But what I will do is just quickly go through it now. It's not a huge change in terms of what's actually in the directive, because the original directive had, broadly speaking, the same definition. But a few key changes that I just want to highlight for you. First of all, you're going to need to keep a record of consent from now on. There will actually have to be a specific record that somebody has consented and how they consented and what they consented to. Realistically speaking, that means you're going to need to gain written evidence of that. The consent has to be distinguishable from other matters. It can't be hidden in a list of terms and conditions. It can't be agreed to as part of signing up to the terms and conditions. It also has to be easily understood. It can't be in complex legalese language. It has to be very, very clear what people are consenting to. It also must be opt-in. Opt-out is specifically prohibited under the GDPR, except in some very unusual circumstances where there's a slight crossover with the privacy and electronic communications regulations. The other important thing to note is that consent can be withdrawn at any time by the individual, and it must be as easy to withdraw the consent as it was to provide it. There must be no barriers in the way for people to withdraw their consent. Now, one of the things that's important to note here is this means that if you make consenting to processing a condition of using a service or product, that is unlikely to be valid consent. And that is another really, really important note on consent. So that's kind of a very, very quick comparison between the two in terms of the main things. And I think hopefully that has kind of demonstrated that if you're doing things all right under the DPA, there's not too much to worry about in terms of the GDPR. What I am just going to do now is focus on 3 particular areas that come up particularly in relation to more technologically minded individuals or for internet-based services. So hopefully these 3 things will be of interest to you all. First thing, the right to erasure, or as it's more popularly known, I say popularly, I absolutely hate the phrase the right to be forgotten, because by my understanding it's massively misleading. It is not the right to be forgotten at all, and I think that's led to a lot of misunderstanding in the press over what this right actually gives to people. As you'd imagine, we get asked about this a lot. It's not a fundamental right, and that is the first thing to note. A number of grounds must apply in order for a right to erasure request to be a valid request, and we'll go through those shortly. As we looked at previously, the right to erasure was actually already there in the previous legislation, just not as a specific right. If you look at the fifth principle, it says that personal data shall not be retained for longer than is necessary. That's broadly speaking the right that we are talking about here. What's happened is there's been court cases. So Mario Costeja, if anybody's familiar with that name, I do feel sorry for that bloke because now everybody knows who he is and he just wanted it to be forgotten about, but there we go. There is a bit of an irony there. He has at least enabled that right for everybody else. I'm sure it'll be of great comfort to him. Broadly speaking, what has happened is that you've ended up with this being focused very much on search engines. So it's about the right to have delisting at search engines. But actually, the right to erasure doesn't just apply to search engines. It applies to any organisations, and that's really important to note. Don't think that you can avoid this just, that it just relates to search engines. So when does a right to erasure request actually apply? So one or more grounds in Article 17.1 must apply to the request in order for it to be valid. And I think hopefully this might set some minds at rest about whether or not you're going to get an absolute mountain of these and it's going to be a nightmare. So we'll just have a quick look through these ones. A request will be valid where the personal data is no longer necessary in relation to the purpose for which it was processed. Right. If you're still processing that personal data when it's no longer necessary, you're in breach of Article 5.1e. Okay, so you're actually breaching the GDPR straight away, regardless of whether or not somebody's made a request. So you shouldn't be doing it. Where the data subject withdraws their consent for the processing and no other lawful basis applies, you have no lawful basis for that processing. You shouldn't be processing it, again, according to the law. Where the data subject objects to the processing under Article 21, and there are no overriding legitimate grounds that exist for its continuance. Again, that's a legitimate objection under the legislation that requires you to stop that processing. Not too complicated. Where the personal data has been unlawfully processed, I'm not going to explain that one further. I think it's probably, hopefully, fairly self-explanatory. If it's, unlawfully processed, you shouldn't be doing it in the first place. Where the personal data have to be erased for compliance with a legal obligation, again, you're under a legal obligation to delete that. So you still have to do it. So the one area where effectively this is a right that is not already afforded by other pieces of the legislation is where the personal data were collected in relation to the offering of an information society service that is aimed at children. Does anybody in the room think that's likely to apply to them? I'm genuinely interested there, actually. That's not a rhetorical question. So there's quite literally one person in a whole room of people here that actually applies to. Right, okay. So two people, again. And that does mean that actually this is a change that you will need to consider. However, it's then not an absolute right in that respect. You have exemptions. Under Article 17.3, if the processing is necessary for any of those reasons, exercising freedom of expression, compliance with a legal obligation, reasons of public interest, archiving purposes, I should point out, it's archiving purposes in the public interest, before any of you look at that too greedily. Scientific or historical research or statistical purposes, or the establishing or exercising or defending of legal claims. So, in practice, we're going to have to see how this works out. Two things we get asked about an awful lot, and I suspect it's probably crossed many of your minds already. How does this apply to backups? How does it apply to blockchain? The first thing we would always say, if anybody asks us for advice on this, is think about the purpose of your processing. Think about whether it's necessary and whether or not that request is valid. If it is, you may still have to comply with it. There is no exemption just that says that it's technically difficult. Okay? The takeaway from this is that if you are designing a new backup system or you're looking to do something with blockchain in the future that is going to involve the processing of personal data, have a look at where those a request might be valid and see whether that's going to apply to your processing. If it is, you need to design your systems now with the right to erasure in mind. Okay? If you've got systems that are already in place, about the one thing I would say at this stage is think pragmatically. As the ICO, we take a pragmatic approach to a number of things, including enforcement. I won't go into details on... If you'd like to talk to me about that afterwards, please come and find me. I won't go into details now, because I've still got quite a lot to get through and not very much time. So, another thing of interest, data processors. This is a definition that fits, probably, I suspect, an awful lot of people in the room. Hosting companies, cloud providers, in some cases web design companies. There's nothing particularly new about the actual definition of data processors. Data processors is still the same definition, but there are new responsibilities. So, Article 32, which is a security article, taking into account the state of the art, etc., 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 the controller and the processor shall implement appropriate technical and organisational measures to ensure a level of security appropriate to the risk. This means that the security obligation is now on data processors as well as on data controllers. And yes, that does mean fines as well. Data processors can now be fined for breaches of the DPA. Sorry, not the DPA, the GDPR. It's been 10 years. I really am struggling to make sure that I get the cross between the two. If it's any comfort to any data processors in the room, it's only the fines of up to 10 million euros. At least it's not 20 million. Small comfort. So what this means in practice is that data processors will have to make sure their security measures are appropriate for the personal data being held. This should be specified under instruction from the data controller. So you should be making sure that you have contracts in place with the data controller that very clearly specify the level of security that you should be applying to the personal data that you are processing as a data processor. You'll be helped in this, that's an obligation under the controller as well, and if they fail to do that, they are liable. Okay? But what this does mean is that there could be some circumstances where data processors get things wrong and they will be liable. Okay? What could this look like in practice? Complicated, basically, is likely to be the answer. But I'll just give you a very, very quick scenario that might hopefully kind of get you thinking around some of the circumstances where this could apply. So, let's say you have an organisation that decides to utilise an infrastructure as a service provider as back-end storage for an app that they're providing to their customers. There's an incident at the provider's data centre which leads to the theft of a server rack. One of the servers stolen contains the back-end storage for that app, and as a result, the personal data of all of the organisation's customers has been compromised. Okay? Now, what's going to happen here is that you're going to need to really think about what measures are we responsible for as a data processor. If we've messed up on those, we could be liable. Yeah? If it's to do with the contractual requirements, if there's contractual requirements, the organisation has said, you need these contractual requirements, you should have this level of security, and you have applied that, you will not be liable. But if you failed in the provision of those, then there is a good chance that as a data processor you may be liable. Okay? The data controller still has responsibilities to choose a data processor that offers sufficient guarantees, and they have to specify the security that is required. The processor has an obligation to ensure that those are in place and they're maintained properly. Okay? GDPR and other laws. I'm not going to talk about e-privacy, even though I suspect some of you would like to, because that is still going through the European Parliament at the moment, I'm afraid. So what I will do is just very quickly, although I'm running out of time, I'm going to have to skim through this very, very quickly, talk about the Network and Information Systems Directive and now the regulation, which was laid before Parliament last week. So, supervisory authorities. These are the regulators for NIS. How many people are likely to be a DSP under the NIS Directive, if you're even familiar with it? Okay. I'm going to assume that there are people who aren't familiar with NIS then, but there we go. So, what NIS is about, it's about the security of network systems, basically. And what you have is you have two tiers. You have an operator of essential services, and then you have digital service providers. Now, the ICO is down to regulate for digital service providers. And what I'm just very quickly going to go through here, rather than going into the actual requirements, I'm just going to very, very quickly skim through the incident notification things for when you are covered by the ICO. So a NIS incident is any event having an actual adverse effect on the security of network and information systems, which I know is different, obviously, to a personal data breach. I'll very, very quickly try to wrap up now by going through these next few slides. So there's some examples for how the reporting would work. This is how it works under GDPR. Data controller reports to us, data processor reports to data controller to us. Under NIS, if an incident covers both, we will potentially get one report just from an OES. And where it's a DSP, a digital service provider, we will potentially get 2 notifications. Okay? Again, slightly different way of looking at it, but we'd still potentially get 2 notifications. The incident report should cover these. Fortunately, all these slides are up on the so if I'm flicking through these quickly, you can actually see these slides later on. The difference between the two can be summarized as this. All personal data breaches are security incidents, but not all security incidents are personal data breaches. NIS concerns disruption to services rather than breaches of personal data. But what it does mean is that you'll be reporting a lot more incidents to the ICO. The statutory instrument has now been laid down. I won't go through the details of the penalty regime because I am out of time. But just be aware that you could be subject to penalties of up to £17 million. And we have specified a cooperative approach. The government has specified that. But there is no specific requirements in the legislation to avoid potential double fining. And then the guidance is already there, so I will very, very quickly skip through that. And I'll just say we do now have more guidance available.
I think we've won a consensus might have a lot of questions, and we don't have a lot of time, so I thought I'd interrupt there for that. Thank you for that, Jonathan. That was great.
There's an awful lot of content.
Does anyone have a question? There's one at the back there.
Hi there. So one of the things that I'm slightly worried about as somebody who works for a software development company that consumes a lot of software that's by cloning Git repositories. So my understanding of the GDPR, and this is obviously stupid in practice, is that when I clone a Git repository onto my company's servers, I am taking a copy of a whole bunch of personal data in the form of names and email addresses of all the people who've contributed to that repository. And theoretically, I have a legal basis of legitimate interest for using that data, but I should inform every contributor to every Git repository that I clone that I now have a copy of their personally identifying information and what their rights are. Now, technically with Git, you can't actually remove someone's author data from the Git commit because it breaks the entire development tree. But I suspect an awful lot of contributors would be quite annoyed if they get an email every time someone clones one of their Git repositories.
Yes.
There's not a lot you can do about it.
No. This is one of those scenarios where I would again emphasise that the ICO takes a pragmatic approach.
Depending on how the budget's looking.
Yeah. If only that were the case, we don't keep the fines. They go back into the consolidated fund. To kind of address your question specifically, you're right. I think it would annoy an awful lot of people if they were consistently getting email addresses. Now, what I would say is think about your purposes very, very carefully. Okay? If you're cloning that repository and it's almost incidental to the processing that you're doing that actually all those names and email addresses are in there, what is the actual impact on those individuals? Is there actually any material impact on them? Yes, that is very true, and that is actually something that would factor in if you did have a security incident. So I'm afraid I'm not going to be able to set your mind at ease on that one. Yeah, exactly. Now, what I would say is that that is information that you've not directly obtained from the data subject, and there is a carve-out for fair processing information where it would involve a disproportionate effort to provide such fair processing information. What I would say is just to be careful, make sure that at the very least you've at least thought about what fair processing information you would provide if you were going to do it. So if somebody does come to you and says, you've got this, you can say, it's quite literally sat on a server that is protected by this, this and this, and we are doing nothing with it other than holding it. Okay?
Any other, one question down here.
Am I right to assume...
Hold on, wait for the mic, please, sir.
Because I'm close, you can hear me.
Yes, nobody else can.
Sadly, the guy in Glasgow who's watching can't.
Understood.
And doesn't have a loud TV anyway.
Is it right to assume that the regulations are retrospective? So, for example, with regard to consent that was given, it now needs to be recorded. But if it's an agreement that has been made 5 years ago, does that now mean that that agreement, that consent is no longer effective because it wasn't recorded? And not just consent, but obviously all the other provisions.
Yes. It has to meet the standard that now applies. So if you can look at your consents and say, actually, they meet the GDPR standard. We have a record of it. It was properly consented. It's as easy to, you know, all the conditions I talked about, then no, you won't need to refresh them. If it doesn't, then yes, you will need to refresh your consents. And this is why you will all be receiving a lot of emails at the moment saying, please, please, please let us carry on being on your mailing list.
Unsubscribe.
No, other way around, but yeah.
Supplementary question.
Yep.
And who defines public interest?
That is a balancing test that you have to do. Public interest is a complicated topic.
A judge, usually.
It is not... It's a recognised legal concept that you will be able to get advice. I apologise for this phrase in advance. You will be able to get advice from lawyers on. It is not what the public happens to be interested in. Okay? It is more along the lines of what is actually in the benefit of the public as a whole.
So a commercial company is unlikely to be able to make a claim to public interest if it's just something
if their interest is basically we want to make more money, then yeah, stretching it for public interest, definitely.
I have a very quick question and we'll draw up. So
Yep.
we often hear from various people about a fine related to the amount of revenue that you make if you're an organisation. Is that true?
Yes, GDPR has two limits basically. One fine is up to 10 million euros or up to 2% of the company's global turnover, whichever is largest. And then the second tier of fines, which is related to breaches of things like fair processing requirements, is up to 20 million euros or up to 4% of global turnover. Again, whichever is largest.
4% of global turnover.
4% of global turnover.
Wow.
Yeah, I didn't go into fines because it's quite a big topic, but that is one of the big changes, obviously. The previous fine was 500,000, and we've still never quite reached 500,000.
Okay, thank you for that, Jonathan. That was great. Thank you.
No worries. Thank you very much.